Article 99, your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the President or the Deputy President must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, your lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC. We all know, my ladies, my lords.
My lord, may I kindly seek your guidance? When Mr. Njiru started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our client. So we're seeking that we get a formal thing that will enable us to seek instructions.
Remind me your name.
Dr. Kamodo for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that will mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordship. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiru, my understanding, when you first asked for this conservative order under Madu paper,
yes, sir.
It was...
That is his application. Yeah. I have on a different application. I moved under
because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big
Your Lordship,
application.
I am well guided.
So I think for the purposes of the discretion of the
Yes,
bench,
Lordship.
for the purposes of the discretion of the bench,
Yes,
I
Lordship.
think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24. That due to the vulnerability of the rights and the vulnerability of the infringement and violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have
Not
my
right.
time and then have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sand, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president.
Objection.
I rest my case.
My Lord, let me respond to.
So that Professor Ojenda and every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
If, my Lord, if I may respond, my Lord. My Lord, you made a ruling.
Okay. Okay, let me hear two people from this side and two people.
And two. You're one person.
Dr. Kamilwa, please say what you want to say and be mindful of time, please.
Yeah, I want